New Overtime Regulations webinar. Please let me introduce Claudia St. John. Claudia, take it away.
Thanks, Chris. Let me first by thanking Chris Spallman and Kevin Gammonley and the team at Smith Buckland. They're the ones who did all the heavy lifting putting this together, and without their effort we wouldn't be able to do this. And for those of you who don't know, Smith Buckland is the premier association management firm in the United States, and they manage a number of the associations that we're partner with. So welcome everybody. We are overwhelmed by the response. Let me introduce myself and Charlotte. I'm Claudia St. John. I'm the president of Affinity HR Group. And Charlotte, who is on with me but does not have a video camera, is our VP of Compliance, and she will be adding color commentary as we go through. Say hi, Charlotte.
Hello.
So a little bit about us. Affinity HR Group is a national HR consulting firm, and we partner with trade associations and other industry groups to provide HR support to their small business members. Typically those members don't have on hand, in-house, an HR person who is fully up to speed with all the compliance issues. So we provide that level of support, whether it's doing an employee handbook or helping them with recruiting and selection of talent, or issues like we're going to be talking about today. So today we are here to talk about the new exciting news with the White House and Department of Labor's new release of the new standard for the FLSA. We're going to go into that in a second, but just a little roadmap of what this is going to look like today. We want to go through what this change is, why we're here today, what we're talking about, a little bit of background on the Fair Labor Standards Act and how it relates to you and what you do, some suggestions or alternatives that are available to companies who are impacted by this new impact and change, and also take your questions. We received a lot of questions, and so we're going to try and have this go about 30 minutes, and then after that we're going to be opening the floor to questions. We will be taking questions throughout. Chris is over there. He's got his microphone muted now, but he is running interference for us. So as we're going through, if there are questions, this is entirely intended to be informative for you. So we want to provide as much information as possible and answer your questions if possible. We have a stop at the top of the hour for those on the East Coast. That's going to be 2 o'clock, but we will stay on the line to answer your questions. So if your question has not been answered, we will stay on the line for those of you who want to stay on and have the benefit of those questions. So let's get into it. So the big news is, yes, the minimum salary to be considered exempt from the Fair Labor Standards Act is going up, and it's going up to $47,476 dollars, which is $900 and I gotta look at my notes, $913 on a per week basis. So that's the big news. We're going to go into that. We're going to explain what that means. What is that? Who does that apply to? But first we want to answer the question of why. Why is the administration doing this? What is the purpose of doing this, this change? And the reason is there are some industries out there, particularly in retail and in the restaurant sector, that over time have been classifying their shift workers or their managers or some of the folks that have some elevated level of responsibility as exempt. And in doing so, they have paid them a salary and they are not eligible for overtime or for time and a half overtime. So for example, you might have somebody, and the minimum right now, and we're going to go into this in more detail, is $23,660. So you could have a shift worker at one of these types of establishments making about $30,000 a year, but then working about 60 hours a week. So when you calculate it on a per hour basis, they're making much, much less than the minimum in order to be considered exempt, and are not getting the benefit of overtime. So the administration viewed this as a challenge. This was really the target of why they were making this change, in order to elevate the threshold of who would be considered exempt. It swept the rest of us up in the meantime. So that was the purpose. It sounds like a really good purpose, but those of you and I on this call know that more people are impacted than just these types of establishments. My clicker is slow to click, so nope, that's not what I want to do. There we go. So first the basics. Let's talk about the basics. The Fair Labor Standards Act. The Fair Labor Standards Act is basically the bedrock of our labor law, and it was established in the 1930s, and what it provides are all of the wage and hour requirements that exist today that our current labor laws are based on. And how the rule works is that it established that workers generally, and at that point the vast majority of workers, were generally entitled to get paid for all of the time that they worked, and any time, and they were entitled to a minimum wage, and any time that they worked over 40 hours in a pay period, they were eligible for overtime. So when we talk about exempt and not exempt, this is what we're talking about, whether they're exempt or not exempt from the minimum wage and overtime provisions of the Fair Labor Standards Act. So what we're talking about today are those who are considered today exempt from the Fair Labor Standards Act. So to be considered exempt from the FLSA, there basically are three thresholds that a company has to make, or that an employee has to satisfy to be exempt from overtime and the minimum wage. The first is that they get paid on a salary basis. So they get paid a set rate, whether they work 50 hours or 30 hours. It's the same week after week, month after month. So they're truly working on a salaried basis, a non-variable pay basis. The second is that their salary level has to be currently, today, at least $455 a week or $23,660 in a year. That's what's changing. So this whole conversation that we're going to be having today is about this particular change. It is now going up from $455 to $913 a week or $47,476 a year. So those of you who should be really paying attention right now are those of you who have exempt employees who are currently earning less than that minimum, less than $413 or $913 a week. So the Fair Labor Standards Act first says you have to be paid on a salaried basis. You have to get paid currently at least $455. Again, that's going up. And the third is that you have to pass a duties test in order to be considered exempt. You have to have some sort of a white-collar exemption that shows that your level of responsibility and authority meets the standard in order to be exempt from the Fair Labor Standards Act. There are a number of exemptions that exist, and they include executive, administrative, outside sales, professionals, highly skilled. We're just going to focus on the first three of these because this is really where most of the exemptions that we see for our clients fall. This is the standard that most folks are working on when they talk about exempt employees. Charlotte, have I said anything wrong so far? Anything you want to add?
No, you've got it.
Okay. So the first is the executive exemption, and this is the one that we see folks using when they have supervisors or managers, the folks who are kind of overseeing other folks in the industry or in the organization. So this is the executive exemption. So to be considered exempt from the overtime and minimum wage provisions of the FLSA, all of the following have to exist. First, you have to get paid on a salaried basis today, at least $455 a week, going forward $913 a week. Your primary duty has to be managing the enterprise or managing a subset or division or department of the enterprise. So think about profit and loss, true managerial responsibility, either of the enterprise or subset. And you must customarily manage or direct the work of at least 2 full-time employees other than yourself. And then the big one, you must have the authority to hire and fire, promote or demote, or have enough significance in your opinion that your opinion will be given weight when hiring or firing or promoting or demoting. A lot of folks that get the title of supervisor can satisfy some of them, but where the misclassification comes in is when they really don't have the discretion to hire and fire at will, or whose opinions are really not taken into consideration. So this is what we see with the executive exemption. So Charlotte, any thoughts on that?
Yeah, just a couple of really brief points for the supervision of at least 2 or more full-time employees. That can also be the equivalent. So if you have part-time employees, as long as the sum of those employees equal the equivalent of 2 full-time, that meets the criteria. And also, this is where I get a lot of questions from owners that say, okay, by definition, as the owner, I fall under this executive exemption. However, I don't always pay myself a salary. I can't. I'm the owner, profit, loss, whatever. It's important to note that there is a carve out for owners of the organization that own at least 20% of the organization and are actively engaged in the organization do not have to meet this criteria. They can automatically be exempt. So if you fall in that, don't worry, you don't have to do this.
Excellent. All right, so that's the executive exemption. The next is the administrative exemption, and this is where we see a lot of folks classify their office managers or their customer service reps or other people who are sort of integral to the operation of the organization, but maybe not in supervisory responsibilities. Again, all of the following have to be met. They have to be paid on a salary basis. They have to be paid $455 today, $913 going forward. Their primary duty must be the performance of office or non-manual work in an organization in the operation of an employer or the employer's customer. And their primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So this is important because people will say, well, yeah, they can absolutely, they have a lot of judgment and they do make decisions that are important. Independent judgment basically means that they can engage the company in some sort of financial or contractual obligation. Let's think about a customer service rep. A customer service rep or somebody who's doing pricing or procurement, do they have the authority to go outside of the realm or the structure that's existed for them and price something completely independent or do something completely out of the standards that have been set for them to operate in? If they do, or let's say they're the ones who are setting those standards and are looking at the margins and the loss ratios and are able to really set those standards, then yes, they would satisfy that exemption. But if they're just following a script, an if-then sort of scenario within pretty rigid or even not so rigid confines, they're probably not exempt. And we have a lot of our clients, when we sit down with them, we discover that a lot of their customer service reps, if they're in the insurance industry, their inside and account management folks, they're really not satisfying that exemption. Thoughts on that, Charlotte?
I would say that this is where not relying on titles and actually job duties is extremely critical. I see a lot of office managers. You throw in that word manager and think managing the office, and you think, yeah, they meet the criteria, but when you really pick apart what is this individual actually doing and what kind of commitment can they engage the organization in contractually in those level of duties. There's a big difference between I can negotiate whether I'm going to buy the paper from Staples or Office Max, or I can set the standard that the entire company is going to do this and I'm going to negotiate the contract and no one can deviate from my policy. Big difference in what the individual actually does.
So you could actually have two people, going back to the customer service rep, one who's following the script and one who's writing the script, one who's actually coming up with the pricing. You could have two people with the same titles. One would qualify as exempt and one wouldn't.
Absolutely. This is why job descriptions are so important, and to understand what our people are actually doing and not just the title that we've given them.
Excellent. Thank you.
Claudia, we have a few questions that came in. A few of them I think will be addressed later in the presentation, so I want to hold off until we get closer to the end. There is one that is relevant to this discussion, and it is, can you give an example of managing the enterprise? I have an employee that falls into an exempt category, but she does not manage any people.
So let's think of an oil change establishment or a car wash. They may be responsible for scheduling, for the operations, for the P&L, for making sure that the stacks are filled with product and whatnot. So that might be operating or responsible for the operational management. But to satisfy that exemption, they also have to manage people. So Charlotte?
No, actually, this is a great example of where an individual may not meet the criteria in one category, but possibly will in another. So in this particular example, they probably don't meet the definition of the executive exemption, but they may very well meet the definition under the administrative exemption, because it sounds like at the surface their duty, their primary duty is the performance of that non-manual work directly related to the management or the operations. And typically that criteria there on the screen for administrative, it thinks of the positions like marketing, human resources, accounting, pricing, finance. Those are the typical departments that kind of fall under this exemption. So again, you're thinking of that title manager, may not be executive, but absolutely could go to another one. So if you miss one category, look at the next one.
Keep going. Thanks, Chris. Okay, speaking of keep going, why don't we keep going? So the third exemption that we're going to talk about today is the outside sales exemption. Again, all three of these have to be met, or all of the following have to be met. The primary duty must be making sales or obtaining orders or getting contracts that for which a consideration will be paid. So for which there is commission or bonus tied incentive paid for that action and paid either by the client or by the customer. And the employee must customarily and regularly be engaged away from the workplace. So away from places of business. This is your typical regional sales manager, your person who's got all of their product in the car and they're out calling on customers. This is not your inside salesperson. This is not somebody who's staying in your office and just making outbound calls and emails. Those would not satisfy the outside sales exemption. But once you do satisfy the outside sales exemption, there is no minimum salary threshold for outside sales. So this issue of raising the minimum threshold for exemption to $47,000 and change would not apply to a true outside salesperson if they satisfy this exemption. Any thoughts on that, Charlotte?
Nope, that's perfect.
Perfect, I love it. So there are a number of exemptions that the Fair Labor Standards Act has over time put in place. They include computer, professional, highly compensated employees, etc. Google Department of Labor DOL fact sheet number 17. If you do that, you will come up with 17A, and that will give you a list of all of the exemptions that are out there, and then 17B through J give you a summary of all of the individual ones, so whether it's administrative or executive or outside sales. It's really important, and the reason why we've spent so much time on this is we should not be just paying attention to that salary. We should be paying attention to whether or not they're satisfying the duties requirement of the Fair Labor Standards Act. And oftentimes we will find that they don't. And we could find situations where you have folks who are getting paid well more than the new threshold, so $55,000, but they don't satisfy the duties test. So we encourage you to take a look at this stuff. It is all gray. It is not black and white, and that's why you need somebody usually to help you work through some of these things. We're happy to be there to help you, your labor attorney, your local HR consultant, but this is the heavier, the harder part, really, of the whole employee classification process. The salary is an easy thing. We just look at the numbers, but understanding this duties threshold is really the hard part of this exercise. So what did change? First of all, this will be effective December 1st of this year, 2016. So the first thing that did not change is the duties test. There was word that it would change the duties test, but that has not changed. What did change was that they increased that minimum salary again from $913 or $47,476 a year. The salary threshold will also be adjusted going forward. They set that threshold, and historically it has been targeted to the average wage, where 40% of the population falls below it and 60% falls above it. So what they did is they targeted the average wage, and they set this threshold at the 40th percentile. But they didn't just look at the whole country. They looked at the lowest wage portion of our country. So they looked at the southern states and did an average across the southern region and took the 40th percentile of that southern region. Going forward, they're going to be updating it, so as that wage increases over time in the South, so will the minimum wage for all of us. And Charlotte, when is the next adjustment going forward?
They're going to be doing this every 3 years, and they will do the first adjustment in January 2020. So just because you bring someone up to the minimum now, in January 2020, you'll have a new minimum that has to be met.
And historically, it's been changed based on whatever administration is in office, and they look at it and think, yeah, we really need to true this up. But obviously, it's been a long time considering that they've just made. The good news, sort of, kind of, is that up to 10% of non-discretionary bonuses and commissions can be calculated into that salary. So 10% of that salary can be commission-based. But lots of red flags. We're going to talk about that. It is not the panacea that we all hope it's going to be, because administering this thing, first of all, there's not a lot of guidance, and it has the potential to be quite a nightmare. And finally, they increased the minimum threshold to be considered a highly compensated employee from $100,000 a year to $134,000 a year. I did receive a question over the weekend. Does somebody who's making $60,000 or $70,000 qualify as a highly compensated employee? No. Currently, it's $100,000. It's going forward to $134,000. So again, here it is in a snapshot. Where we were, 455 going to 913, or $47,476. Again, and I'm going to be a broken record on this, you have got to be paying attention to the duties test as well. It's not just the salary, it is also the duties. So let's take a minute, and I'm going to ask Charlotte to help us with this, but up to 10% of the minimum salary may be paid through non-discretionary bonuses and incentive pay and commission. It has to be paid at least quarterly. Employers have one pay period after the end of each quarter to make up any shortfall. So if that person doesn't satisfy their non-discretionary bonus to get them up to that $47,476 level, the employer has to make that up, or they have to reclassify them. The details of how this is going to be administered have not yet been provided, but Charlotte, give us an idea of how confusing this is going to be, or could be.
It sounds good on paper, but in practical application, there's a lot to be resolved, and at this point, we can only make some assumptions. We do know that the 10% of the minimum salary level can only be you can only count non-discretionary bonuses toward that. So anything that you decide to do on a whim, hey, you're doing great, here's this, those kinds of things don't count. Non-discretionary figures are typically things that you set clear parameters that say if this happens, then this happens, and then based on meeting those parameters, you receive X. So that's non-discretionary. They also must be paid at least quarterly. It doesn't mean you can't pay more often than that. Some organizations prefer to do monthly, but you definitely can't do less often than quarterly. And then when you get to the end of a quarter, you have to go back and do the math and determine, at the end of the day, when I consider what I paid my employee in their base salary, and I add in their commission or incentive pay for the quarter, does the math work out to be $913 per week for that quarter or not? If it doesn't, then you have to go back and pay them the difference so that the calculation is that over the course of the quarter, their average earnings each week are at least $913. And the thing that I think will trip up a lot of companies in this is you must make this calculation and pay out the shortfall within the first pay period of the new quarter. It takes time to figure out, based on your commission structure, chargebacks and returns and revenue and all those pieces that go into it, and to have to come up with that and do the math and pay out a shortfall in the first pay period in the new quarter is a pretty steep hill. And when you can only include up to 10% of the $913 as commission, then you have to start assessing, are the dollar amounts I can get out of this worth the administrative burden that it may create? So Too soon to know what any of this will really mean. We're just going to wait and see in the coming weeks if we get more guidance beyond the generic up to 10% may be paid through non-discretionary bonuses.
And the only other thing I would add to that is if they don't make that amount and they've fallen short and there hasn't been a makeup, then we haven't received guidance, but it's quite possible you're going to have to go back through, estimate the number of hours that the person worked during that pay period and pay them overtime for any time that they attest or assess that they worked during that time. And then we don't know, are you able to go in and out of exemption versus non-exemption? So this is a big hot mess, and if you're thinking about using it, I would only even consider it if you know that discretion or non-discretionary bonus is going to kick them way over that minimum threshold on a regular basis. Salary calculations. They cannot include discretionary bonuses, so hey, you did a great job, here you go. Board, lodging, or other facilities, payments for medical, disability, or life insurance, contribution to retirement plans, I did get that question, or any other fringe benefits. So again, these are purely the commissions that you get or the bonuses that you get as a result of a calculation that was set prior based on certain performance targets that have to be met. So what's an employer to do? So there are some scenarios that we'd like to put forward for you, some basic strategies for you to consider. The first is, the most obvious, is to increase the salary to the new minimum. And what I know I will say, because if I don't say it, Charlotte's going to jump in, which is you will never go wrong paying somebody an hourly basis, treating somebody as a non-exempt employee, giving them eligibility to overtime and minimum wage. You can treat everybody, you can pay everybody on an hourly basis. You will never go wrong. You will never make a mistake by doing that. Was that good, Charlotte?
Yeah, because when you think of it in its basic terms, the law is concerning itself with if a person is eligible for overtime and the minimum wage. And if you choose to do that, even if they qualify as exempt, you've met the minimum requirements of the law and can't get in trouble that way. So that's your safe bet.
The other is to reclassify reclassify your exempt employee to non-exempt and pay them on an hourly basis, track their time, and give them overtime. So just as you're treating other hourly employees now, that's how you would treat this employee going forward. Then there's some different opportunities. So you don't have to pay them a salary. You can reclassify them to non-exempt, pay them a salary, but you're still going to need to track their hours, and if they work in excess of 40 hours in a pay period, then you have to pay, or within a week, then you have to pay them overtime. So none of the strategies that we're putting forward here, if you're paying them less than $47,476, you're always going to have to keep track of their time. You're always going to have to pay them time and a half for any time worked over 40 hours. The last is a scenario that I know some of our clients are thinking about, and that's basically, so take the customer service rep who currently is making $40,000 a year today, and she works 8 hours overtime. She works 48 hours a week. What you can do is adjust pay, her hourly pay, so that when you take her hourly pay for those 40 hours and you take her overtime pay for those typical 8 hours in a week, and you calculate overtime for that, so that the whole package would equate to that $40,000. So again, if she works 49 hours, you're going to have to pay her that extra hour. But you can structure the job or structure the pay in a way so that roughly you end up being whole. Again, it's not easy. It's a lot of work, and the big challenge for you going forward is to manage this. You're going to have to manage hours and treating people on an hourly basis. And if they go into overtime, what's your saying, Charlotte, about managing those folks in overtime?
Yeah, if they go into unauthorized overtime, remember that you still have to pay them for overtime when they work it, regardless of whether or not it was permitted. I always remind people that unauthorized overtime is a disciplinary issue, not a payroll issue. So you can certainly discipline employees for not following your policies on working or getting overtime approved and those kinds of things, but you still must pay them for the actual hours that they have worked.
So some critical things for you to remember. The first is that you still have to satisfy that duties test, and this is a big area of mistake for a lot of small businesses that they work with. Make sure that your classifications are correct. So no matter whether you satisfy the salary or not, you need to make sure those duties are in line with those exemptions. Communication to employees and to your supervisors going forward is going to be essential, and Charlotte and I were talking about this beforehand. The Department of the press has really spun this story, right? It is out there, and your folks are listening to it and talking about it. Your employees know that this is out there. I was at a session last week, and there were a lot of young millennials there, and they were totally psyched because they're making about $36,000 a year living in New York City, and to be able to get overtime for all the work, they're very psyched about this. So you may not be, they may be, and there are going to be a lot of people waiting to see how this is going to be rolled out. So the communication is going to be essential. You have to remember that your salaried employees, your exempt employees today, if they're non-exempt going forward, they're used to checking their email from home. They're used to working on the weekend. That is all commensable time. So going forward, they have to be reminded, and you have to keep track of the fact that when they're doing work for you, whether it's in their pajamas or from a bathtub somewhere, it is still time that is that has to be counted toward their overall hourly rate. Training.
Well, just jump in here real quick and let you know we have a bunch of questions that are coming up. We are at the 30-minute mark. Just wanted to give you the heads up there.
Great, thank you. So we're just going to go through this slide, and then we're going to cut it over to questions. So let's go through this. Thank you, Chris. Training and managing time for the new managers is going to be a new challenge. They're all of a sudden going to have to be, keeping track of how much and when and where people are working. So they're going to need some training and some coaching on this. And then my parting thought to you is that you may think that the Department of Labor is not going to come knocking on your door, and chances are I'd take that bet. I think they're probably not. But you're only as safe as your last bad hire. So somebody who thinks that they're entitled to something, or somebody who thinks that they deserve something that they're not getting, especially now given all the press around this issue, it is super easy for them to pick up the phone and call the Department of Labor, to pick up the phone to call the EEOC, or you don't have to look anywhere to find a lot of ambulance-chasing lawyers who are happy to take on class action suits within specific industries in order to tackle some of these misclassifications. Again, we've seen it definitely in both the building service trades and the insurance trades. So
I think,
sorry, Charlotte.
I was just going to say, I think this is a great place to remember that when you're considering this change, not just looking at the financial side of it, considering your culture, how your employees work. Do you have a very strong telecommuting environment? Do you operate in a 7-day work week? Just taking all those things into consideration beyond the financial piece to what makes sense for your employees and your situation going forward has to be part of the conversation, not just what does this do financially.
Excellent. So some resources, again, we told you about DOL fact sheet number 17. If you Google DOL and overtime, they've got two really very solid websites right now, DOL.gov/featured overtime and the DOL overtime final 2016. There's a ton of resources in here. There's a whole bunch of questions and answers. There is a guide for private employers on how to administer these changes and what these mean and what you're required to do. So they've actually taken the time to build out a lot of material when they launched this. So I'm pretty impressed with at least the stuff that they've got out there already, although the 10% is still a little lacking. I'm going to show you this slide. I'm going to show it to you at the end as well. We're always here to help. This is what we do. We're given the large scale of this change, we're offering one-on-one consultations. So if you'd like to sign up for one of them, by the end of this week we're going to offer a pretty severely discounted fee of $60 for a 30-minute consultation, and all you do is you go to Affinity HR Group appointee.com, and I'll be showing this again at the end, and there's our contact information. I wanted to show that to you because now we're going to go through the questions, and I imagine some of you will drop off at the 1 hour mark, but we encourage you to stay. If you're having fun and are well engaged, we encourage you to do that. So I was thinking about going through the questions that they asked first, Chris, or should we go through the questions that came through to you? What is your thinking?
Why don't you go through the ones that were asked first so that you respond, and if any of them are actually covered, then we can skip over that on the ones that asked.
Okay, that sounds great. So the first question, we have a long-time great employee who works more than 40 hours even though we ask her not to. How are we going to handle this? Well, first of all, we're assuming that this is somebody who is now going to be classified as hourly, who was exempt and is now going to be considered non-exempt. And I think Charlotte touched on it, and that is this now becomes a disciplinary issue, not a payroll issue. So setting those expectations, figuring out why she's working those extra hours, and taking that into consideration in terms of how you restructure her. You know, maybe that idea of saying she needs that 48 hours, let's build her compensation to satisfy that 48 hours, and taking a unique look at that. We don't want to harm people who are great and love what they do just because of this law. Let's figure out a way to structure it for them. Thoughts on that, Charlotte?
No, that's perfect.
What level of contributions to an employee's 401k, will contributions to 401k count towards the salary level? So we've already answered that, no. Those benefits do not count. How will this affect our sales folks on 100% commission? Well, if they satisfy the outside sales duties test, it doesn't affect them at all. But if they're inside, or they are some combination of inside and outside, or they're not sales folks, they are doing something else for 100% commission, then it could have the impact of affecting them significantly, so much so that you'll have to pay them at least the minimum threshold plus the 10% to get them to that amount.
And there's no requirement that for those on a base plus commission or whatever, there's no requirement that that 10% formula be followed. You can choose to ensure that their guaranteed salary is the minimum $913 a week and adjust your commission structure for amounts over that going forward, and you're fine. Yeah.
So basically, if they're consistently going over that, just build in that base, satisfy that issue, and then give them commission over that. As the owner and an employee of my company, will I have to pay myself the minimum salary? Charlotte, you already answered this, but what was your answer again?
If you're a bona fide owner of 20% or more of the organization, then you are exempt from this criteria to begin with.
Got it. Do bonuses count toward meeting the minimum salary requirement? We've already answered that. The answer is discretionary bonuses, no. Non-discretionary bonuses, perhaps. Can bonuses used in that calculation be applied monthly or only quarterly? So again, monthly, as much as quarterly, but more frequently than that. What classifications are still exempt from overtime? All of them, really. Those classifications haven't changed. It's just the minimum salary threshold has changed. So all of the current exemptions that exist will continue to exist. It's just that the first of the three things that they have to satisfy, which is paid on a salary basis, paid a minimum salary, it's that minimum salary that now has to be satisfied. Where does an employee go if they feel they're incorrectly classified? Charlotte, do you want to answer this?
Yeah, well, ideally you have a policy in your handbook for addressing this, where if an employee has a concern about their classification or payroll status, whether it's your finance department, human resources, certainly we would hope that there's an open door policy that would allow them to comfortably come talk to someone in management about their classification. However, keep in mind that employees are entitled to go to their state Department of Labor or the Federal Department of Labor and file a complaint that they believe that they are being improperly classified and being denied overtime wages that they have earned. And of course, to Claudia's point, there are also those ambulance-chasing attorneys out there that would be more than happy to take on the case if they feel that it's valid.
How can I be sure I'm classifying my employees correctly? Well, I think the first place you want to go to is that DOL fact sheet series that I referenced. I think also having a conversation with a human resources professional or a legal professional, somebody who knows how to apply these standards is critical. But if you read through those, especially the administrative exemption and the executive exemption, those are where most folks get hung up. So I would start there. And of course, call us. If an employee works 50 hours a week one week and 30 hours the next week, but our pay period is 2 weeks and they worked 80 hours in total, do you owe the overtime for the extra 10 hours that you had in that first week? The answer is, except in very, very restricted circumstances, yes. So you would need to pay them that extra time and a half for that 10 hours that they worked in that first week.
Yeah, keep in mind that every week, 7-day period stands alone when calculating overtime.
So your pay period might be 2 weeks, your pay period might be 1 month, but for the purposes of the Fair Labor Standards Act, you're calculating it on a 7-day, 40-hour work period. Does this impact any salaried person who's earning more than the minimum? And what is a highly compensated employee? So no, this does not impact anybody who's getting paid more. If they're getting paid $50,000 or $60,000, it does not impact them. But you should still check the duties test because that is still a threshold that they have to meet. Highly compensated doesn't kick in until currently $100,000 or $134,000 going forward. I have an inside salesperson earning a base salary of $31,500 a year. Do I need to pay them overtime for their extra effort in trying to increase their sales targets? So if they're not meeting their numbers and they're working extra time just to get those sales targets, do I now have to pay them for that time? Yes. If they're working on your behalf, whether they're doing that or filing or Lord knows what else, you need to pay them for time and a half, anything over 40 hours in that work week. Other questions? So what do you have, Chris?
Oh, we got a lot of questions. This is a very engaged group. I'm going to go in order, and I will give you time to answer each one, but I'll ask them one at a time. First question from Jay. Are there any exemptions for IT personnel?
Yes, there are. There's a computer exemption. Charlotte, do you know what that is offhand?
Yeah, the computer exemption applies to employees who are truly involved in the design and creation, if you will. They are not employees who are involved in the repair of or manufacturing of computers. Help desk employees do not meet the criteria for it. The other thing about the computer exemption is this is one where in lieu of the $455 a week or $913 as of December, the computer exempt professional can also be paid hourly as long as their hourly rate is at least $27.63 per hour. And in that case, you can pay them hourly straight time for their overtime too. You're not necessarily paying a time and a half, but as long as they're making the $27.63, they're considered exempt from the overtime provisions.
Is that going up, the $27.63?
No.
Okay.
No, and that equivalent just is around $57,000, just to put it in perspective.
Okay.
All right. Another question from Jay. He had back-to-back. What is the likelihood that a new president who disagrees with this ruling will change this order?
It depends. They do have a lot of authority. So this is an administrative function. We got a lot of questions before about, well, how is Congress going to let this go through? This is not a congressional act. This is an administrative act. So it's entirely within the duties of the administrative, of whoever is the president at that time. I think the reason why the Obama administration came out so early with this is because they wanted it to be implemented and up and running so that it would make it harder for people to say, okay, now you're no longer eligible for overtime. So that was the calculation, but certainly a new president who is not so inclined to keep this provision in office or in order will be able to scale that back or change it. Politically, I think it's going to be a little bit of a tough sell just because when you talk with folks who are now eligible for overtime, it's a pretty appealing thing.
All right, thank you. A question from Douglas. I have seen inspection companies, normally on a day rate, coming back to the courts to get back pay for major overtime. Is this also being addressed in this regard?
I think it's the same thing. I think it's that was a group of people who viewed themselves as being classified as exempt, and they should be classified as non-exempt. So it's not really. The only thing that's changed here is the minimum salary threshold. That question of whether or not we were classified appropriately and eligible for overtime in the first place continues and will continue. This does not fix that at all.
And I think, I was going to say, I think it's also important to note while we've been talking here that to qualify as exempt, one of the criteria is you have to be paid on a salary. The reverse for non-exempt is not true. Just because you're non-exempt does not mean that you have to be paid on an hourly basis. Non-exempt employees may be paid at a piece rate or commission, combination of things, whatever, but at the end of the day, the math has to work to ensure that they do receive the minimum wage and time and a half for all the hours they actually do work, even if they originally weren't paid on an hourly basis. The math still has to work.
All right. Next question from Tanner. Are there exemptions for emergency responders?
There are. Charlotte.
I can't speak to that.
I believe there are. So if you go through the Department of Labor fact sheets, I believe they have one for emergency workers. So police, hospital, first responder types, I believe, have other standards that apply to them. I don't know how this affects that specifically.
Thank you. From Jim, what is the definition of non-discretionary bonus?
So I'll give it my shot and then I'll let Charlotte answer. Non-discretionary is basically we have established between the two of us that I have to meet certain sales goals, or I have to perform certain functions, I have to accomplish certain tasks that are prescribed ahead of time and mutually agreed upon, for which I'm going to get pay. And then as a result of that, as we go forward, I've satisfied those requirements, I've satisfied those objectives, and so that pay is due to me. The employer doesn't have the right to offer it or not offer it. It's part of the agreement in terms of setting forward that responsibility. Not a discretionary bonus would be your holiday bonus, where you hand out $50 to this person and $200 to that person, or an attaboy or attagirl for a job well done, or you've had a good quarter and you want to pitch some money back to people as a sort of feel-good thing. That would be considered discretionary.
Thank you. From Amy, we have 2 employees who are on the cusp. With their bonus, they go over $913 a week, and the bonus is awarded in December.
So they would have to award those bonuses on a quarterly basis, no more than a quarterly basis. If they're on the cusp or if they're close to it, you should probably consider just bringing them up to the minimum and then offering that final bonus based on what the difference would be from what they would get at that new salary level. That would be my guess. How about you, Charlotte?
Yeah, and keeping in mind that if you go that route, you truly only have that first pay period in the new quarter to do the calculation and make the payment to bring them up to the salary minimum, or they lose their exemption.
On a similar vein, from Jolene, for the catch-up payment for bonuses included, is the calculation done on standalone quarterly basis or year-to-date but paid quarterly?
I don't think that we have enough clarity on that. Charlotte, what do you think?
No, we don't at this point. A lot of assumptions going around about what the calculation actually means, you know, and even right down to what happens if the employee terminates mid-quarter. What does that do with it? What if you get to the end and the catch-up was larger than you expected? All these questions have yet to be answered on the practical application of that 10%.
From Walter, we have truck drivers that work 12 hours a day and are paid on salary. They make less than $913 a week. Do we pay OT to these employees?
Currently, I believe you should. If they are employees and they don't satisfy any of the exemptions that I know of, they should be paid on an hourly basis and they would be eligible for that overtime. That not having any, I mean, I don't like to say things that are sort of broad sweeping judgments because again, you have to look at each position and each duty and could they satisfy any of the other exemptions. But my best guess is that they probably are already eligible for overtime because I don't know what exemption they would be offered under. Charlotte?
I agree.
Yeah. Give us a call.
All right, from Kathy. Where can we find a copy of the duties TES?
The duties test, yes. So if you Google USDOL fact sheet number 17, so USDOL fact sheet 17, that will give you 17A has a roll-up of all of the duties, all of the exemptions, and then fact sheet 17B, C, D, E on down will give you a summary of each of the specific exemptions. And the duties test, it's called the duties test, are contained therein. Or if you can't find it, just shoot us an email and we'll send you that link.
Excellent. From Steve, is this based on 8 hours a day or 40 hours per week?
40 hours per week. Although in some states, you want to, I know what you're going to say.
You took the words right out of my mouth.
So what we've been talking about entirely on this call are the federal standards, but you have to realize that there are states that have more rigorous standards. So every state has at least what we're talking about here, but some states have more. So some states set that minimum wage, that minimum number of hours on a weekday basis, 8 hours as opposed to 40 hours in a week. So California, what are some of the states that applies to? Charlotte, do you know off the top of your head?
California is the big one, and just always keeping in mind when you're looking at okay, my state says I have to do this, but the federal government says I have to do this. When in doubt, you always do the one that's the most generous. In this case, gives the most cash advantage to the employee. And keep well-documented records of the direction you took and why.
Yes.
In your calculation.
On all things.
Yes.
From Kathy, if you reclassify to non-exempt and pay salary, does the employee need to turn in a time card each pay period to document hours?
Yes, so whether it's a time card or whether it's a date stamp on their computer or whether it's an Excel spreadsheet or whether it's written on the back of a napkin, they have to submit the number of hours that they've worked within that pay period. So yes, that is an obligation that they have to keep track of. They have to keep track of those hours. Because in the end, if they don't and they come back and say, well, I worked overtime, if you haven't collected that time, which you're obligated to under the Fair Labor Standards Act, then 9 times out of 10, they're going to favor the employees. So it's going to, whenever there's a question, it's your word against theirs, they favor their word because it was your obligation to be keeping track of this time all along.
And keep in mind that hourly and salary, those are employees' payroll status.
Right.
Exempt and non-exempt is the legal status that we're talking about today. And in the FLSA, the record-keeping requirements for a non-exempt employee includes that hour information, hours or worked information.
Next up from Elizabeth. The fluctuating work week wasn't discussed. Can you provide an example and an opinion on this method?
Oh, so like a flex time, compressed work weeks or compressed and extended work weeks? Do you think that's what she's talking about, Susan?
That's what I believe.
Mm-hmm. So to date, well, if they are non-exempt, and they, in a work week, they're working more than 40 hours, they need to be paid that extra time. So I'm not quite sure. I'm not quite sure what that looks like. Charlotte, how about you?
Well, the fluctuating work week is one that definitely causes a lot of angst from employers, and we're not going to be able to answer the question for purposes of this call. But the first question that typically has to get asked in that scenario is, when you think about the individual's base salary, what was that salary intended to cover? And whether, you know, this person's their salary is based on 35 hours or 40 hours or whatever. So then there's also a little known criteria that to operate on the fluctuating work week, that an individual has to have that understanding and agreement up front. So if you hired someone and said, I'm going to pay you $600 and that's it, but I'll give you overtime, if you didn't have that agreement established up front that it's a fluctuating work week and what that salary is intended to cover, then you don't meet the criteria for operating on a fluctuating work week. So lots of criteria there, but at the end of the day, when the individual works more than 40 hours, they're going to have to be paid overtime. The question will become whether that salary has already covered the full-time piece and they're just due the half-time, or if they're due an entire time and a half based on those hours over 40.
So I wanted to chime in. One of our consultants who's listening in on us has sent me a text. Thank you, Paige. She said there is an exemption for motor carriers, which should or could apply to truck drivers. So if you're still out there and haven't hung up the phone and discussed, there is a potential exemption for you there. So take a look at the motor carrier exemption. And then she also mentions that fluctuating work weeks also has a distinct seasonal component to it as well. So that needs to be looked at. If you're talking just a seasonal thing, or if it's an ongoing thing, that is impacted as well.
And as a further follow-up from Elizabeth, fluctuating work week is a promise to pay a non-exempt employee a salary regardless of hours worked, only pay OT at 50% if they work over 40.
It's time and a half. So what you would need to do is you would need to calculate the hourly rate, which is a multiplication of, you take their salary, whatever you've agreed to, and you divide it by 2080, which is the number of hours in a year, and that will give you the hourly rate. And it's based on that you need to provide time and a half.
All right. Next question from Mary. I have an employee that is paid below the salary basis. Her hours are 9 to 5. However, she arrives at work at 7:30 and leaves at 5:30 because she relies on a ride to work from someone else. Would this be classified as overtime?
It depends on what she's doing during that time. If she's sweeping or if she's tidying up the kitchen in the workplace, then yes. If she is sitting outside and reading a book and enjoying the sunshine, then no. So it's entirely a function of what she's doing during those hours. Even if she's not doing her normal job, but she's doing something else, cleaning up the mailroom or just making herself useful during that time, then yes, that does factor into that calculation.
Okay. From Jason, does this impact commission techs working on flag hours?
I don't even know what that is. Charlotte, do you know what a commission?
I'm not sure what that question is asking either.
And Jason, if you would like to, if you could actually retype in some more clarification on that question, we can come back to it. From Jamie, could Claudia explain more about the fourth strategy, which was reclassify as non-exempt, restructure hours and position? I'm not understanding why this would be beneficial or how it is different from paying salary plus OT, which is the third option listed. You know, if you want to pull up your slide, it could work to help with that.
Sure. All right, so, the third is basically you pay them a salary. Okay, so going forward, you were making $34,000 a year. So we're just going to continue to make you $34,000 a year, but we're going to track your hours, and any work week that you work more than an hour, or any time that you work in overtime in that pay period, we're going to take the hourly rate, which again is taking that salary and dividing it by 2080, and we're going to pay you time and a half on that hourly rate. So what makes that different from the fourth bullet is let's say we have somebody who consistently, you know, they work 48 hours a week. It's not that they're working 40 and occasionally dip into that extra hour. They're always over it. You set their base rate not at if they were making $30,000 a year before. You don't set that base rate at $35,000. You set that base rate lower, and you factor into it the consideration that 8 hours of every pay period is going to be time and a half, so that at the end you're approximating that $35,000 mark. But again, you're going to have to pay them if they work 49 hours, you're going to have to adjust it up if they go over those overtime hours. So what you've done in the first scenario is you're just taking their current salary and you're just saying, just keep, go forth and carry on, but we're going to pay you overtime. The other is we're going to pay you an hourly rate that's much less than the hourly rate that you're currently working at, but that then takes into consideration all this overtime, so at the end you're made whole. I hope that makes sense.
Next question from Joe. If you reclass someone as non-exempt, are you on the hook for any past OT?
So it depends. The courts basically say they give a good faith effort that if you just discover that you've had misclassified employees and you try to do the right thing as soon as possible to classify them correctly going forward, they don't typically do any grand look back. But if somebody catches you having a misclassified employee, or somebody files a complaint because they feel that they've been misclassified, that look back I think can go 2 years. Is that correct, Charlotte?
2 years or 3 years if it's a willful. And this is actually one of the reasons why right now is a good opportunity to go through that duties test, because it's very hard to go to an employee to say, oh, we should have been paying you overtime all this time, and then run that risk that, because at the end of the day, if you find out that they've been misclassified, yes, technically you should go back and correct any overtime errors. However, right now, doing this under the guise of the salary change, at least that's what's getting the focus right now. So the efforts to right the ship now and go forward are less likely to run into that experience, because it's being precipitated by the salary piece, not, oh no, we've misclassified you from the get-go. So in a practical application, I see a lot of employers making these corrections now using the salary as their cover for the reasoning. And
all right. From Wendy, are salaried employees that work after hours that are paid well over the minimum eligible to be paid OT?
Are salaried, read that again?
Sure. Are salaried employees that work after hours that are paid well over the minimum eligible to be paid OT?
This gets to the question of the duties test. So if they've hit that salary threshold out of the ballpark, right? Their base pay is $55,000, then typically no, but you still want to go back through and make sure that they satisfy whatever exemption you're classifying them under, whatever that duties test is. So nurses, for example, they do a lot of shift work, they do a lot of after hours work. You want to make sure that they're satisfying that exemption first, and then you're safe because their income is above that minimum.
And at the end of the day, keeping in mind that whether you're paying them salary or whatever, if they don't meet the criteria to be exempt, then all the way around they are entitled to overtime, regardless of how much they're being paid the salary. If their duties don't meet the criteria to be exempt, they have to get overtime.
From Cheryl, is a truck driver who is paid an hourly rate plus mileage, or an outside salesman paid a salary plus a commission, exempt from the salaries test?
So definitely yes on the latter. on this outside sales who works on commission, yes, they are exempt. If they satisfy that outside sales exemption, then yes. I've been made aware for the first time about this exemption for automotive drivers, so I can't speak to that. I would need to understand it a little bit more and do a little bit more research on that.
All right, next is one of the big unknowns is exactly how many hours our exempt employees are working now. So should we use time systems now to track or test or see how many actual hours exempt employees are working without converting them to non-exempt until December 1st?
Yes, absolutely.
Because keep in mind that there's nothing that prevents you from tracking the hours of an exempt employee. And in some organizations you have to, because maybe computer organizations, maybe that's billable time that you have to bill a client. Or maybe it's a government contract that you have to be able to bill the hours actually worked. So there's no problem with tracking the hours, but to ensure that they do not lose their exempt status, you're not actually making their pay based on the hours. They're still receiving their salary regardless of those hours, but you can track them, and honestly that is the best way to figure out what's in front of you, to start tracking to get a feel for it.
Chris, I just want to point out that we're at the top of the hour, a little bit past the top of the hour. We're happy to keep going. If those of you who would like to schedule some time to visit with us, just to go through your individual situation, if you go to affinityhrgroup.appointee.com, we've set up some office hours that extend well into June, so that's an easy way to set yourself up for some time. But we're happy to keep going.
All right, next one from Elizabeth. If a currently an exempt employee is making $35,000 and the job description specifies they will work 50 hours per week, can we adjust their hourly rate to reach $35K based on 40 hours straight time and 10 hours overtime? This is typical in retail.
Yes, but except for the 10 hours in overtime, $10 in overtime. So yes, you can absolutely structure their time so that their regular work week is 50 hours. They're getting paid regular pay at 40 hours and then time and a half for 50 hours. Absolutely. As long as you're paying them that time and a half for any overtime, you can work them as hard as you want to work them. Really, there's nothing prohibiting you from working them 80 hours a week, but they have to be getting that time and a half for anything over 40.
From Ryan, does an allocated lunch hour count against the 40 work hours?
Charlotte, I'm going to let you answer that. I hate those questions.
That depends whether they're actually taking their lunch hour. The requirement to take a lunch break and that it's unpaid, that goes back to that unauthorized overtime thing. That's a policy issue and a procedural issue that you have to manage and enforce. And it's up to you as the business to know whether or not your employees are working when they're not supposed to be. So if you've got a lunch hour that's technically not being paid for, but an employee's working through it, they have to be paid for it. You can't just dock them the hour and, oh, well, hey, I'm sorry you didn't take it, but you know, this is how it is. If they work it, they get paid for it.
All right. Next question from Stephen. What do you do with the employee that doesn't work more than 40 hours per week, but is now going to be offended that they are hourly versus salary?
Yeah, you know, I think this is actually one of the hardest questions, because it really is an issue of cultural change. People, to be considered salaried and exempt is sort of it indicates a level of professionalism and a status within an organization that warrants that that allowance. And I think this is one of the hardest things, is trying to explain to people that because of how much you're making, you no longer have that status. I don't right now have a really great answer for you on that. I think it's just acknowledging that this stinks, it's not your decision, and that it's being done in order to help people for whom they're being, you know, there's an element of abuse in terms of what they're being paid and how they're being classified, you know, inappropriately. but for your fellow, my heart goes out. I totally get that. I wouldn't be happy with that situation myself. Hello?
Sorry, from Ryan. Are automotive technicians still exempt if they're getting hourly pay or if they're on flat rate pay?
Are automotive technicians exempt? I think they would have to satisfy one of the maybe highly skilled exemptions. I don't know, and maybe Paige will send me a text, or Charlotte. I don't know that there's a specific exemption for automotive technician, but I know, for example, there is a highly skilled exemption. So, for example, if you were a chef, you would qualify the exemption. If you were a line cook, you would not. So I don't know whether a mechanic, a skilled mechanic, that would probably satisfy an exemption, but I don't know whether a technician would. The title itself tells me maybe not, but again, you can't really go on titles because it's not indicative enough of the duties that they're performing.
All right. Next is from Edward, who just wants another brief recap on the 401k contributions. What was the answer to the 401k contributions? Could you please provide a brief recap?
They do not count toward the 10% of the salary that can be paid in non-discretionary bonuses. So you can't add whatever they would be paid in 401k or flex savings account or health insurance or any of the other fringe benefits. They're not included in that 10%.
Okay. From Suzanne, just to confirm I understood this, the minimum salary of $913 does not apply to outside sales. So if they are paid a base salary under that and then a commission basis, it does not need to be above $913 a week.
That's correct. And what I would encourage you to do is to just look at the duties of that employee. So just because you have them labeled as outside sales, you want to make sure that they're truly satisfying that exemption. So I would go and Google the Department of Labor fact sheet outside sales, DOL fact sheet 17 outside sales, just to confirm. But if they're outside, if they're on the road and they're calling on clients and bringing in the business that way, then that minimum salary does not. They can be 100% commission only.
All right, from Eric. We are using the term employee. Therefore, I assume that there is no requirement to pay a 1099 worker overtime, correct?
No, that's correct, because we are talking about employees. But a lot of fun last year, the Department of Labor reclassified the standards that one could use to be considered an independent contractor. So that standard changed last year. It's not the subject of this conversation, but they've made it much, much more difficult to be considered an independent contractor. So I would definitely go on our website, affinityhr.com, and we wrote a number of blogs last year about this independent contractor basis, and we also you need to make sure that they're being classified correctly as well. Right now the Department of Labor is using one standard and the IRS is using another standard, so that's still kind of hicky. But if they're truly independent contractors, then this does not apply to them.
All right, from Beverly. Are you hearing a lot about how to handle those who are still exempt, asking for increase to remain a certain percentage above that were exempt and are now exempt? I'm guessing non-exempt is there. As they feel they are getting a pay cut since the non-exempt are possibly getting a raise to stay exempt.
So this happens all the time, actually. This is not unique to this new salary threshold, and we see it when all of a sudden you promote an hourly person. They're now a supervisor. Congratulations, you're now a supervisor. And in the end, they're making less because they're losing out on that overtime. So yes, it's a reality. It does happen, and it happens now when people are moved, oftentimes, who had a lot of overtime, are moved into higher level of skill or exempt positions. The only thing you can think about doing is creating an incentive bonus for them so that they have certain things that they can do, measurable performance that you want, that you're looking for them, that they can earn in order to be made whole. But that absolutely happens.
From Karen, can I cut a person's hourly pay to cover anticipated overtime due to this regulation, i.e. a particular position is only worth a certain amount no matter how it is paid?
Yes, so you can cut their, and this is that's sort of my scenario 4, which is you cut their hourly pay lower, anticipating that they're going to have the overtime in order to keep them, from a budgetary standpoint, that same level where they are right now, as long as you don't fall below the minimum wage of whatever, either the federal minimum wage or whatever state minimum wage you have.
From Matt, we have a number of admin representatives that make just over $30,000. To be clear, the salary is fine, but if they work over 40 hours weekly, we must pay time and a half. Do we have to pay this up and until they meet the $47,000 annual threshold, or is this solely based on their base salary?
So the first question is if you have administrative positions and they don't satisfy the administrative exemption, then they need to be paid on an hourly basis with time and a half. Once they hit that $47,000, there's no change. You still have to pay them time and a half. The only reason why you would not have to pay them overtime is if their duties of their job now make them eligible for the exemption that exists under the Fair Labor Standards Act. So you never stop paying them overtime until and at such a time that they satisfy that exemption.
All right. From Mark, does a non-discretionary bonus have to apply to all employees within a group, or can it be applied individually? For example, if we have 4 employees that are getting paid $42,749, 3 of them make enough of a bonus to meet the minimum, but 1 does not. If we change the non-discretionary criteria, does it have to be employed to all 4 employees, or can it be applied just to that 1 employee? If additional bonus is applied to just that 1 employee who didn't make the minimum, would that be considered a non-discretionary employee?
So first we're going to assume that all 4 employees satisfy whatever exemption, the duties test that they're working under. So that's the first thing. So would they qualify as an exempt employee anyway? Would all 4 of them qualify? And then I'm going to say, and Charlotte's going to say, you don't know that, so you can't say that, but I'm going to say it anyway, and that is that you can treat that 4th person differently because they didn't meet the non-discretionary threshold in order to be considered exempt, and so they get kicked back into non-exempt. That's my understanding of it, but Charlotte, how wrong am I?
No, I think that's fine. I think, in looking at it also, these non-discretionary, it's like, you can have different commission incentive plans or whatever for each individual person. So there's no requirement that whatever you've done for these 4 in the past, you have to continue doing for them going forward. Had this similar question asked earlier this morning, and where we kind of ended up with it was, that's where you really have to start thinking about, though, are you going to end up, by doing that, are you going to, is the incentive piece going to punish one person because you're going to count that as part of their wages or their base pay, and will the other employees be rewarded with the incentive piece because they get the incentive free and clear, regardless of what their base wages, and overtime, regardless of what they are. So I think right there, it's not that you can't do it, it's just looking at the bigger picture of what am I trying to accomplish here by tweaking these incentive plans, and am I applying something. It doesn't have to be the same to every employee, but is what I'm applying uniform and fair to each situation that I'm in, and I can justify the business case from one to the next and not creating a discriminatory practice.
From Douglas, what about an employee that is paid on a piecemeal rate?
If assuming that it's a non-exempt employee, that goes back to what I said earlier, that there's no requirement that they be paid on an hourly rate, but at the end of the week, the math calculation for where they have received at least minimum wage and time and a half for all hours worked still has to be done. If for some reason we're saying piecemeal but we're calling them exempt, they're not exempt, because if they were truly exempt, they would be paid on a salary basis, not a piecemeal basis.
All right, from Joe, I have employees who manage branch locations where they're responsible for all aspects of the branch, like sales and supervision. Could be anywhere from 1 to 8 people in a branch. Would they be exempt?
So the branch manager positions, if they truly have P&L, if they're managing the duties of others, and if they have the authority to hire and fire and to heavily weigh into those decisions, that probably would end up being exempt. Now, I know that there are folks who are in the car wash and automotive, the oil change business, and some of those folks, they have schedules that are 55 hours a work week. That's their typical work week. And they have folks who are exempt and would qualify under the duties test of being exempt because they truly do have full managerial responsibility for those shops, but their salary doesn't account for it. So yes, they would be considered exempt, but again, you would need to pay them the new minimum, which would be $47,476. And if you paid them less than that, you would need to reclassify them as non-exempt.
Okay, from Stephanie, how do you figure a salary for an hourly employee on a semi-monthly pay period with inconsistent days in a pay period?
So what you do is you don't look at a pay period. What you do is you take their salary and you divide it out, their annual salary, and you divide it out by 2080, and that will give you your hourly rate. And then you apply that to however fluctuations there are within her, within the employee's pay period. But again, remember that look back period is on a weekly basis. So from Monday to Friday, if that's your work week, if she worked over 40 hours in that pay period, then you need to pay her time and a half for that amount.
That's actually one of the challenges for non-exempt employees in a semi-monthly environment. For exempt employees, it's easy. You can take their annual, divide it by 24 pay periods. But for non-exempt employees, you're going to end the pay period and pay them at that moment, even though it may be the middle of your work week for overtime purposes, but then you would have to go back the following pay period once they've actually worked that week in which the pay period ended, and then do the math to determine, even though my pay period ended, so I paid them this, once the rest of the week ended and their total hours were in, did they work overtime that I now have to go back and pay? So it's doing semi-monthly for non-exempt employees when there's overtime involved is a cumbersome process.
All right, next question from Chuck. If we pay an hourly employee for 30 minutes for lunch, even though they do not work the time, and then work up to 2.5 hours beyond 40 hours in a week, are we required to pay OT for the extra 2.5 hours?
Charlotte?
Now say that again. So I'm paying them for 30 minutes that they're not actually taking?
But then they're working overtime after it. So they worked through their lunch, but now they're working after.
Because if they're not working it, but you paid them for it as time worked, you're going to have a hard time proving, oh no, they didn't work, but I paid them for it. So if they didn't work the time, and you choose not to pay the time, you're fine. But if they don't work the time, but you pay them anyway, you're going to have a hard time convincing the Department of Labor that they didn't actually work it and you were just paying them out of the kindness of your heart. So you need to have clear records of this is exactly how many hours were worked and this is what I paid them for, and at the end of that you have to be able to show that they did receive at a minimum. They received straight time for up to 40 that they actually worked, and a time and a half for anything over 40.
And that's why we see a lot of clients, they clock out, they have their folks clock out for lunch to sort of eliminate that, like, well, you did and you worked over here. Yeah.
I'm sorry, I'm saying ask them to physically leave their workstation. Receptionist is a big challenge for that. They may sit there eat their lunch at their desk and they're reading a book, but all of a sudden during their lunch they pick up the phone and take a call because it's instinct. Well, that unpaid 30-minute break just became paid time because they started performing work during their unpaid period. So seeing more and more employers requesting that employees clock out for lunch and physically leave their workspace.
We still have a fair amount of questions, so I'm going to focus on the ones that have people who are still in attendance. Some of the questions the attendees had to drop off. So from Tanya. Oh, go ahead.
Chris, what I was just going to say is if your question has not been answered, you can feel free to send us an email. Our contact information is here. Or if you want to schedule a time to sit down and talk with us, please do. Or just take this information so that you have it in the future, because we know there are a lot of far-ranging issues, not just the salary issue, but the whole classification of employee and time and hours.
Do you have time for a couple more questions? We do have plenty, but we also are running up on a time of 1:25
Yes.
Central Time, so I want to be cognizant of it.
And plus, you've had about enough, Chris. You've learned about enough about human resources than any human being should have to.
Oh, I love this. So from Tanya, how do you handle employees that are non-exempt but have pager duties? They may or may not take any calls during this time.
Charlotte?
Say that again. Pager duty.
On-call duty.
On-call pay is a whole different beast about whether or not you have to pay for the time. It depends on how much freedom the employee has to come and go as they please during their on-call period. Do they have to remain within a certain distance of the work premises, is their on-call time disrupted so much that they didn't get to reasonably enjoy the on-call time for their own pursuit? So whether or not it would ultimately have to be paid would depend on the specific criteria of the situation, which I'm happy to talk offline with that question.
Sorry, I was on mute. From St. Tanny, can you speak to summer hours where there are 4 days of 9 hours a day and a day of 4 hours, totally 40 hours in a week?
At the federal level, that doesn't matter. It's always going to come back to the 40 hours in the 7-day period, regardless of how that shakes up.
But in California and other states, they do have a minimum on a daily basis, and that would come into play.
Correct.
All right, last question from Trina. What if the normal work week is 37.5 hours? Would you pay overtime based on anything over 40 hours or over 37.5?
Our guidance would be 40 hours. If you are a particularly benevolent employer with a lot of money, then you can set that wherever, but statutorily it kicks in at 40. And setting that work week a little shy like that does give you some wiggle room so that you can avoid some of that overtime. So that's a good position to be in.
All right.
Excellent.
I apologize for the last few questions we couldn't get. What I will do is this has been recorded, and I can take a screenshot and share as well for our presenters in case they can reach out to you. But if you have any other final questions, please feel free to utilize the link listed on the screen. Claudia, any last comment?
Comments? Just thank you so much, Chris and Smith Buckland, for hosting this and for all of you participating. And there will be more as we learn more. We're happy to keep you posted. And just thank you so much for your time, and hope you all have a wonderful afternoon. Thank you, Charlotte.
Thank you.
Thanks, everybody.
Bye.